to issue number 1, Children's Law Center of California. The issue before the subcommittee is the Children's Law Center of California budget request intended to ensure that every child in foster care is provided with effective and high-quality legal representation. I see we are honored with the presence of Judge Jar here from the AOC. Welcome. And I think Leslie Starr, could you help me? Hyvav. From CWLS, Executive Director, Children's Law Center of California. I don't know how you figured out who's going to talk first, but whenever you're ready.
We didn't. I'll speak very briefly and turn things over. First of all, good afternoon, Mr. Chairman and members of the committee. I suppose I would be remiss if I didn't start by thanking you and your subcommittee for your efforts last year to raise onto the radar screen, if you will, the desperate need for reinvestment in the judicial branch. You brought attention to that issue and created the momentum that took us forward in a beginning process, and you also gave us direction. The direction included a request that we report an account to you for the small amount of money that was brought forward, less than you had requested, but certainly better than nothing. You also sought from us a verifiable methodology for telling you what will be required to have a fully functioning branch of government, including, incidentally, that component that pertains to our dependency courts. And more recently, you asked us, what will an additional increment of funding mean in terms of providing access to the citizens around the state and court users around the state? In response to your direction, we did report an account in September. The plans and intentions of all the trial courts to spend that $60 million increment augmentation that was provided in last year's budget, and we will report an account again through the trial courts in April for how the money was actually expended. With regard to your question, what will it take to have a fully functioning branch? The trial court presiding judges and court executive officers developed the workload allocation funding methodology, brought it forward to the Judicial Council, and approved it. And that was the basis upon which the Chief Justice built her budget blueprint, which, of course, you are all conversant with and we have provided to you again today, which includes $33.1 million for enhancement of the budget for Dependency Council, about which more in just one moment. Finally, we will provide to you, and I will have it in your office today before close of business, the results of the drill to the trial court in response to your specific request, what an additional increment of funding beyond the $100 million that Governor Brown proposed in his January budget message would mean in terms of court users and court customers' access to courts throughout our state. I had hoped to have that on hand today in light of the budget items, and I realize the shortness of time that will be once again in your office by the close of business today. With respect to the matter of Dependency Council, for anyone who has practiced in those departments as an attorney or presided over them as a judge, everyone is aware of how excruciatingly important it is that children's best interests are attended to in matters where there are potential out-of-home placements, potential foster care. Family reunification is the ultimate goal, of course. In a nutshell, the current budget for court-appointed counsel is slightly more than $100 million a year statewide, because as you know, whereas district attorneys and public defenders are paid for by the counties in which they practice, dependency counsel appointed by the court are paid for through the state processes, and that process is managed by the Judicial Council. The Chief felt it was incumbent that in our full budget blueprint, that need that has been existent for some time be articulated as a part of our overall, for context, $612 million request for augmentation of the budget of the entire branch. Welfare and Institutions Code Section 317 Subdivision C provides that all children be appointed counsel in dependency proceedings, and all parents who are indigent and whose children are at risk of or subject of potential out-of-home placement also be appointed counsel. As I mentioned, the budget for that is slightly more than $100 million, and at present, statewide, although the numbers vary, the ratio is something like one lawyer for every 250 individuals. Another way of saying it is the attorneys have caseloads of roughly 250 on average. Some years ago, the Judicial Council commissioned a study. It involved roughly 1,000 attorneys in 10 different courts. It was a workload time study, followed by a Delphi process to assess what is the highest number of cases that an attorney practicing dependency law can effectively manage and provide service to his or her client as well as to the court. And that was where the 188 case number was derived from, associated with, I believe, representation of what amounts now to over 142,000 children and parents in California. So we have requested in the budget blueprint that that be one crucial component of our overall budget request. Thank you.
Thank you. Again, Leslie Heimov from Children's Law Center of California. We are a nonprofit law firm. We have been in existence in Los Angeles for 24 years, where we represent almost 29 to 30,000 children. We have also assumed representation of children here in Sacramento. July will be 3 years, and we represent close to 3,000 children here in Sacramento. In the 23 years that I have been with CLC, and I started as a staff attorney quite some time ago, I've seen our caseloads be as high as well over 300 children and as low as close to 200. And the difference in what we can do for a child when we have the 188 or 200 clients versus 250 or the current high of 309 clients is quite remarkable. Our request and our efforts in supporting the Chief Justice's request have come out of years and years of watching caseloads go up in the past several years. In the past 3 years alone, our caseloads have gone up by 4,500 children, but with no additional funding. So the same number of lawyers have 4,500 more clients than they did as we did 3 years ago. Just to give you a comparison, in Colorado, most children's attorneys represent 60 children. In New York, there's a legislative caseload max of 125. In Georgia, there was federal litigation that resulted in a caseload cap of about 90 children per attorney. We feel very strongly that California should not be lagging behind in that standard, but we should be setting the standard. Our laws are some of the most progressive and advanced laws protecting children in our child welfare system, but we can't implement them and we can't enforce them when we have caseloads as we do now. The difference in an attorney with 300 clients versus the 188 that's recommended is the difference between triage and responding to emergencies only and a more proactive approach towards representation. When an attorney meets their client, there's always some trust building. When your client is 8 and has been horrifically abused and perhaps moved from one placement to another, it takes a lot of time to build trust. We can't walk into a room and say, "Good afternoon, nice to meet you, here's what we're going to do today." When we don't have the time to do that, our ability to provide the court with the information that they need is severely compromised, and therefore the quality of the decisions that are made are compromised. And then the well-being of the child, of course, is compromised. In the 20-plus years that CLC has been representing children, we've also seen our responsibilities grow dramatically, in large part because of laws that have been passed here, all good laws in our opinion, but it's added significantly to what is expected of us. It used to be that we would come into court, talk about abuse and neglect charges, and we were done for the day on that particular client. We now appropriately have to attend to the child's educational needs, their mental health needs, their health needs, psychotropic medication, their placement needs. If they get arrested, we participate, and unfortunately some of our youth do get arrested or run into situations with the law. We will participate in their delinquency proceeding as well. And there was a study that was conducted by some professors from Cal State LA and University of Chicago in 2010 that found that the active engagement of a CLC attorney in the delinquency case had a significant impact on improved outcomes for youth who had been arrested, meaning that rather than sinking further into the delinquency system, we were able to get them the quick intervention and services that they needed to quickly exit the delinquency system, stay in the child welfare system, and then go on to a more successful outcome rather than digging deeper and deeper into the criminal justice system. Similarly, a study from 2000 And 8 found that when children's attorneys have manageable caseloads in the state of Florida, permanence came faster, meaning children languished in foster care for a shorter amount of time when their attorney had the opportunity and the time available to actively work towards the goals of permanence. The last thing I'd like to point out is that a significant impact that we are seeing now because of this caseload crisis is an increase in turnover. We are losing experienced attorneys not because they aren't making enough money, which is an important factor, but because they come in, they feel that they're not doing their job. They can't sleep at night because they're concerned about their clients. And that kind of stress on the attorney and their the compassion fatigue or the burnout that comes from having this kind of a caseload has been the stated reason that we have lost several excellent lawyers in the past few years. I would say from where I sit that it takes 3 to 5 years for a lawyer to really become good and have the expertise that they need and the experience that they need in this extremely complicated area of the law. And if we can't keep people because the workload is so cumbersome, children will suffer in that regard as well. And then the last, I did say that was last, but I actually have one more point. The last thing I'd like to point out is that if this allocation is made, all of the money that you're allocating, all of the additional funds will go directly to nonprofits like CLC that actually provide the representation. There's no administrative overhead that's taken out of it. It's not building a pot within the AOC or within a branch of government. It is going into the communities where the lawyers live and work and represent these children and their families. We ask for your support and thank you very much.
Okay. Department of Finance.
Thank you, Madeline McLean, Department of Finance. The governor's budget provides $100 million for trial court operations. We believe this is a sustainable amount given the revenue situation over the long term. And the courts have the ability to prioritize workload to the extent that they identify additional funds are needed for this purpose. They can allocate a portion of those funds to this effort. And also I'd like to note that this should be like a multifaceted effort. Courts can look to identify programs at the local level that would reduce the number of children entering the system as well. So it's not just this portion, it's also looking at reducing the overall population that's entering and utilizing these services.
Okay. And the LAO.
Anita Lee with the Legislative Analyst's Office. In our preliminary look at this issue, we think that it merits consideration. However, we have not determined whether or not this is kind of the most cost-effective and efficient way of addressing this issue.
Okay. So I'll start with the first question. There seems to be concern about cost, and if the state shifted to the draft model, could ratios be improved at a significantly less cost?
So I can respond, although I'm not sure that I should be, but I will anyway. We are a draft county in Los Angeles, okay. And draft speaks to quality of representation. I don't think it speaks to cost saving. I don't think the purpose of draft was to save money. I think the purpose of draft was to improve the quality of representation. I wasn't a creator of draft, so I don't know that, but that's my impression. And I can tell you, CLC is invited to conduct training around the state because we are one of the most experienced. And we have a lot of experience because of our numbers and because we've been around for a long time. And we regularly travel to other counties to train. And our experience has been that the draft county attorneys are generally do have better resources and better training and better knowledge and better oversight. So I think draft has been very effective in terms of quality, but it doesn't appear to me that draft is about saving money or not saving money. It's about ensuring that kids who can't assess the quality of representation that they're getting have lawyers who are doing a good job, because a 6-year-old or an 8-year-old can't look at their attorney and say, I really don't think you're up to par. And I want a new lawyer. They don't have that ability. But the draft program requires a certain level of oversight and supervision that's focused on improving quality and consistency statewide. So I think draft has been very good for our clients and for our practice, but I don't know that it's a cost saver.
Mr. Chairman, the draft program was devised by the Judicial Council. It gave direction to my staff agency. first starting with 10 volunteer courts. It's a volunteer process, which is now expanded to 20 of the 58 superior courts, whose caseloads total something on the order of 60% of all dependency caseloads. And essentially, it's a program if a court chooses to take advantage of that involves competitive bidding models for contracts for dependency counsel. It requires, as has just been indicated, the implementation of standards for the quality of practice. Educational requirements are imposed and met by the Center for Family, Children, and the Courts, which is one of the offices within the AOC. We provide that education. And then, of course, we collect and monitor and analyze data and contract compliance. I agree with the statement that was made that it's no substitute for sufficient funding, though I do understand that there has been some savings that has been identified at around 5%, which obviously wouldn't counterbalance the need that's been articulated today. But I certainly submit to you that it has been an effective program and that the Council has shepherded the dollars that have been provided as well as can be done.
Okay. And I see the LAO squirming in their seat, so
we would agree on the savings related to draft, and I think that in our preliminary analysis, I think that it does raise questions for us if the program was expanded further and you had these issues in terms of competitive bidding on contracts, especially across courts, and essentially leveraging economies of scale, you could potentially generate savings on the contracts. Additionally, in terms of the issue of quality, in terms of contracts, you can essentially craft the contracts in a way that you are ensuring that there's the same level of cost related to attorneys and support staff, so like investigators, et cetera, that is available in a draft court versus a non-draft court. So I think one of the concerns that we have is that the level of resources amongst the different courts, draft versus non-draft, may be different. So that's one of the reasons why we haven't determined if kind of the request as is the most cost-effective and efficient way of delivering service.
Okay. Thank you. Committee members, any questions? Mr. Stone?
Thank you. I don't actually have a question. This is something that I've been involved with, and if none of you have been to a dependency court, I would highly recommend it. It's a world of its own within the justice system, and it's very, very critical. And as we work to try and, yes, as the DOF recommends, try and keep kids out of the dependency system, we still have a situation where there are, in fact, a lot of kids in the dependency system. And whereas we expect lawyers, as they're representing these youth, to know the case, and they can do that by reading the file, it's so critically important that they get to know the kids. And they can't do that when they meet them for the first time just outside the courtroom and then go in. Kids are very particularly reluctant to discuss their situation given what they've been through. They're afraid. All these adults around, given that opportunity to engage with that child at an appropriate level is very, very important to ultimately the success of it. And while we do need to continue to work on reducing the number of kids that come into the dependency system, we also need to ensure that we are funding programs like these. We've had this debate over the last couple of years that we've been involved with, is that with the reduction in funding, critical programs are going lacking in our counties, and this is an example of one of those programs that really is fundamental to our ability to hold on to our children and their families as we move through this process. So I think this is important enough that we ought to fund this. So I'm going to make the motion that we do approve the $33.1 million funding on an annual basis in accordance with the court's blueprint for these dependency court appointed attorneys. This is very important.
Okay. Is there a second?
No, go ahead and second that motion.
Jones Sawyer.
Aye.
Rodriguez. Aye. Stone. Aye. The motion passes.
So, Chief Jar, you public comment? So, there's a saying in my office, don't talk past the yes.
Libby Sanchez on behalf of the County Welfare Directors Association and California Public Defenders Association, in strong support of the yes we've already heard.
Michelle Castro with the Service Employees International Union. We represent the attorneys in the Los Angeles Children's Law Center, and we appreciate your yes vote. And I'm going to defer some comments to Jennifer McCartney, one of the attorneys in the LACLC. Thank you.
Thank you so much for the yes vote. To give you an idea of what some of us attorneys do here at Children's Law Center of Los Angeles and the difference caseload can make. When I first started at CLC, fresh out of law school, I had over 350 clients, and in order to just stay above water, I was there at 6:30 in the morning and didn't go home till 10 o'clock at night. 3 years ago, I adopted my son, and it's not possible for me to stay there until 10 o'clock at night. And so once he goes to bed at 9 o'clock at night, I get on the computer and start processing cases, following up with emails and social workers, trying to stay above water. For some of our clients, we're the only people they want to talk to. And so in order for their voices to be heard and their needs to be met within the child welfare system, they need adequate representation, and that includes having the time to go and see them in their foster homes, go and see them in their parents' homes, so that we have a good idea of the entire circumstances. And this money will go a long way to helping us improve our caseloads. Thank you very much.
Thank you.
Ed Howard, the Children's Advocacy Institute at the University of San Diego School of Law. If you travel the longitude and latitude of those Californians who have the highest moral claim on the money that comes into our general fund, you will find no group of Californians who have a higher priority and a higher moral claim to that money than the 74,000 children who we, by force of law, collectively have removed from the care of our parents and assumed sole and total responsibility to care for them and raise them right than ourselves. If you likewise consider the fact that it takes longer and more hours to represent a child effectively in court than it does to staff a bill, imagine each of your staff with a bill load of 250 to 300 bills, and you will get some sense of how currently the situation is preposterous and, in fact, a species of neglecting and abusing the children all over again. And while the Chief Justice is massively to be congratulated, and we are very grateful for including the blueprint, the $33.1 million, in response to Department of Finance's comment, in the past we have been unable to persuade the AOC to prioritize the financing of these children. It is this legislature reflecting this priority and our moral values that respectfully needs to do it, and we thank you so much for the vote that you just took. Thank you so, so much.
Martha Guerrero, representing the Los Angeles County Board of Supervisors, in support and appreciation for the action just approved.
Kyle Sporleader with the California Youth Connection. CYC's membership consists of current and former foster youth ages 14 through 24, spanning 32 of the counties throughout the state. And our members, who are these current and former foster youth, are thrilled every year to come to Sacramento and advocate for legislation that will change the law to better the foster care system. They are less thrilled to see ineffective implementation and enforcement of these laws once they're changed and once they get back to those counties. So this budget item and allocating this money towards decreasing the caseloads for dependency attorneys is a right step towards making sure we do our due diligence by these children. Thank you.
Good afternoon. Rachel Ewing, Supervising Attorney Law Office of Ladle, which is the parent. We represent the parents in the courts. We'd like to thank you for the allocation and for this support of families and families reuniting. Thank you.
Susanna Niffen with Children Now. I'm here in support. Really, these attorneys are the only true voice of the children in the courtroom. So on behalf of the young people who can't speak for themselves, thank you for your vote.
Kevin Asnian, Coalition California Welfare Rights Organization, in strong support of the motion that passed. Thank you.
Gail Johnson Vaughn, Mission Focused Solutions. We're an independent child advocacy organization working to open the doors of permanent families for children in foster care. Having adequate legal representation for our dependent children is crucial, a critical element to assuring that these children return home as quickly as possible, and if that's not possible, that have permanent families quickly, securely, and sustained. Thank you for supporting the action.
Good afternoon. My name is Jacqueline Carey Wilson. I'm president of the Riverside County Bar Association and deputy county counsel in San Bernardino County. And for many years, I've represented the Department of Children's Services in dependency appeals when the parent or appeals normally. And in the past, we've had a minors counsel appointed on every appellate appeal so that their voice could be heard in the appeal. But over the years, that has declined, and now unless the minor is appealing, their voice is not heard at the appeal. So I wanted to voice my concern for more appellate counsel for minor children, and hopefully some of the funds could be used towards that. Thank you.
Okay, thank you. I think this is in the spirit of the discussion of the school-to-prison pipeline and really trying to close it on the front end so that we can squeeze the number of people that go into prison. And so I think in the spirit of that, that's where the motion came from. We still have a long budget process to go through. Pray for a great May revise. That's always helpful. And so we'll go on to the next item, the collaborative courts. And Judge Jar, are you still speaking?
I think I'm kicking. I think I'm kicking things off.
Elio.
So I'm kicking things off on this
Well,
one.
that's good, because he's costing me money. He's a silver-tongued devil over here.
So Anita Lee with the Legislative Analyst's Office again. So committee staff asked us to kind of provide a little bit of context and background for your discussion this afternoon. So collaborative courts focus on combining judicial supervision with rehabilitative services in order to help participants focus on recovery and to reduce the likelihood of recidivism. Typically, offenders are allowed to avoid prison or jail time if they participate in these rehabilitation programs and avoid further criminal conduct. Looking on your agenda on pages 13 and 14, you can see that nearly every trial court has at least one type of collaborative court. Collaborative courts can range widely from adult and juvenile drug courts to mental health courts to elder courts and reentry courts. Additionally, individual trial courts, in working with their local criminal justice partners, can operate the same type of collaborative court differently. For example, drug courts may differ in the types of violations that are eligible for inclusion in the court. The success of collaborative courts and the associated savings depends on a number of factors, including one, how the collaborative court is structured and operated, two, what violations are eligible for inclusion, and finally, what best practices are used by the court. Collaborative courts can help reduce both the state prison and county jail population in two ways. First, offenders who are participating in the programs are generally kept in the community and are not in jail or prison while they're participating in the program. Second, by incentivizing offenders participating in such rehabilitation programs, the collaborative courts help prevent participants from being sentenced to prison or jail in the future. And this is an important function because both the state prison and county jails are under some population pressures. The state is currently in the process of trying to comply with a federal court order to reduce prison overcrowding. While the administration's plan is likely to attain compliance in the short run, it may not be able to attain or maintain compliance in the long run. So accordingly, the state will likely want to consider other options for further reducing the state's prison population in the coming years. Similarly, many county jails are also experiencing overcrowding. For example, many of our county jail facilities are under self-imposed or court-imposed population caps. As of June 2013, 39 facilities in 19 counties were operating under such population caps. When the facility exceeds their cap, essentially what happens is they release the inmates early. So, for example, in the first half of 2013, an average of about 13,000 inmates per month were released early. turning to kind of costs and, related to collaborative courts, the judicial branch and trial courts do incur some costs related to collaborative courts, but it only benefits from a small portion of the savings that the courts generate. Counties in the state really benefit the most from fewer individuals re-entering the state prison or county jail system. So just as a reminder, since 2009, trial courts have received a series of ongoing general fund reductions that totaled $724 million in 2012-13. It was subsequently reduced to $664 million in 2013-14. To address the reductions that were not offset by increased revenue from alternative sources, trial courts took a variety of actions. Some of these actions you've heard about in terms of reducing clerk office hours or closing courtrooms or courthouses have effectively resulted in reductions in public access to court services. At the same time, trial courts have also made reductions to non-mandated court services and programs, such as collaborative courts, to free up funds to meet other operational obligations. Heading into 2014-15, it is possible that further reductions may occur if nothing changes, because the trial courts are still in the process of operationalizing and addressing reductions from prior years.